Hi, everybody, and welcome to our webinar teaching about the Trump v. U.S. decision. Thanks so much for coming tonight. We're excited to have great experts with us and to deep dive into this decision and also sprinkle in some teaching suggestions. This is our agenda. We're going to try to stick to it. A very brief welcome and introduction of our experts. Some background facts, precedents, and arguments about the Trump v. U.S. case. So we're all on the same level playing field. We're going to talk about a teaching activity we call classifying arguments. And then we're going to talk a lot about the decision and the opinions. Another teaching activity we call unmarked opinions. And then we're going to talk about the short-term impact of this case, what happened immediately, and give our experts a chance to weigh in on what they see as the long-term impacts and how this case might be important in the future. We're going to do our very best to save a lot of time for Q&A so that you can get your questions answered. There's a QR code there and a bit.ly that will take you to a list of links for today. So everything we're going to use today, you can download free from our resource library. And that will take you to all of the teaching activities, and it will take you to our case summary, which we'll talk a little bit more about later, that will allow you to use this case in your classroom, hopefully easily. I'm going to be your host tonight. My name is Kathy Ruffing. That's my title, Senior Director, Teacher Professional Development and Curriculum. I've been with Straight Law for a little over 6 years now. I spent 27 years teaching in Fairfax County Public Schools, and I taught mostly AP Government and a law elective. And now this is my second career. So Street Law, if you're not familiar with us, you probably are because you found this webinar, but just in case, we are a global nonpartisan nonprofit organization. We work on law-related and democracy education. We have all sorts of buckets of work. I work in the teacher professional development side, but we also have community initiatives and global work that we do. You can see on the screen there our vision and our mission. So now I want to take the time to introduce our guests for tonight. We're really fortunate to have two great legal experts to help guide us in our deep dive. Our first guest is Kim Wehle. She is a law professor at the University of Baltimore School of Law. You can see her on all sorts of TV programs, ABC News, Politico, The Atlantic, Bulwark. She writes, she's on for a lot of publications. She's on media because she is an expert in constitutional law, separation of powers, presidential power, and you'll see in her long list of books that she has a book that's about to come out next week, September 2nd, on the pardon power, how the pardon system works and why, so very timely. And before going to the University of Baltimore School of Law, she was an assistant U.S. attorney. So I'll let Kim say hi and tell you a little bit more about herself and the book, maybe.
Oh, well, thank you so much. I'm so delighted to be here. I have a big spot in my heart for educators and teachers, and I really appreciate the opportunity to sort of bring the law school classroom into, people's education outside the elite environment of law school and getting behind the why of the Constitution, not just the what, but understanding functionally why it works the way it works, I think is really critical. At least that really helps how I teach my law students. If they understand the why, they understand the what. So that's where a lot of the titles of my 4 books come from, and really looking forward to this discussion with my friend Gregg, and appreciate the invitation. Thank you.
Okay, that's great. Lead into Gregg Nunziata. the executive director of the Society for the Rule of Law, and maybe he can tell us a little more about that organization. He is also president of Rock Spring Public Policy. He also appears on lots of media and does a lot of writing. You've probably seen his name and his face. One of the things that we love about having Gregg as an expert is if you look at the types of outlets that he writes for and appears on, you can see that he covers all the bases. And before this most recent part of his career, he was Republican Senate staffer, and he worked on the Senate Committee for the Judiciary and the George W. Bush administration. So Gregg, you can say a little hello and tell us maybe just a little bit more about the Society for the Rule of Law.
Sure. Hi. It's great to be here. I love street law and I love the kind of programming you do. I've been happy to play a role in the Supreme Court Summer Institute now for, I think, over 10 years running. It's a great program. This is a great organization. For better or for worse, I did do nominations in the Senate Judiciary Committee, and I had a hand in the confirmation proceedings for a majority of the court in one way or another. And we'll talk a bit about all those folks today. The Society for the Rule of Law is a relatively new organization that was founded about a year ago, which at its core is conservative and libertarian lawyers who prioritize the defense of the rule of law, the Constitution, and American democracy over partisan or policy issues. So we try to take a longer view of those kinds of fundamental principles. I said at our core, we're conservative and libertarian lawyers, but we have members that are neither conservatives nor libertarians nor lawyers. And we are trying to do more work actually with non-legal audiences in mind. I think we have a lot of programming this fall in that direction, because we really do deeply believe that these constitutional issues are too important to be cared for only by lawyers, and they really belong to all citizens, and we're hoping to engage them all. So would encourage you all to check out our website and sign up for updates. I hope we'll have some more programming that would be useful to you and to your classes in the months to come.
Yeah. And you said you're going to have some programming with Kim as a guest, correct?
Yes, I should have mentioned that. I'm sorry. I think it's not been announced yet. I think it'll be announced tomorrow morning.
Whoops, did I just?
No, I believe it's going to be announced tomorrow morning, and I think it's a week from Tuesday. We're going to do a discussion. Kim and I are going to talk about her book on the pardon power and why it's so relevant today. So really looking forward to that. The details will be on our website, societyforruleoflaw.org tomorrow, but I believe it is noon on Tuesday after this Tuesday, so about a week and a half.
Great. Sorry if I wasn't supposed to say that.
No. Thank you.
So I want to start by saying one of the materials that Street Law makes available for teachers are case summaries of cases from the current term, and this was made available before Trump v. US was argued. And this is the same link as before. You can access this case summary there. We're going to talk you through it tonight, so you don't need to, but if you want to follow along, we're going to follow very closely this case summary. But it's also something that you could use in your classroom. When we write these, we strive for about a 10th grade reading level, and any legal jargon that's in there that we don't expect teachers or students to understand, we make sure that we define within the reading. We include, they are very formulaic, so they're all set up the same. So once your students start to work with them, they'll become very familiar with the format. There's always a background section, and then the facts of the case, the issue in the case, precedents and constitutional provisions, arguments for both sides, and then after there is a decision and the opinion, there are summaries of those as well. So you can access the Trump v. US one. You do need to make an account to download something from the Street Law website, but it is very quick, and everything is free. So where you can find in the future, if you're looking for these cases from the current term, if you go to the Street Law website and you go to teacher resources, it's going to take you to what we call our resource library. And you just click resources and SCOTUS in the classroom. SCOTUS stands for Supreme Court of the United States. So SCOTUS in the classroom, and then you can find these cases, because the teaching techniques I'm going to talk about today can be used for any of these cases. The URL for the street law store is, or it's not really a store. You're not going to have to pay any money, but it is store.streetlaw.org. Okay, so just to review some vocabulary before we start talking, because likely Gregg and Kim are going to use these terms. And if you're not familiar with them, it's good to know. If you are familiar with them, know that you'll likely have to review them with your students. Maybe they're not common everyday language. The first is who is a petitioner. So if Gregg and Kim refer to petitioners, they mean the party who is asking or petitioning the court to hear the case. So in this case, since it's Trump v. US, it's Donald Trump. It's always the name that comes before the V. And you can always tell that this person is the person who was not successful at the court below, right? Because if you're successful at the court below, you don't want anyone else to look at the decision. You're happy with it. But if you're unhappy with it, you're going to want to take it to a higher court. So unless it is a rare original jurisdiction case in the Supreme Court, there's usually just one of those each term. The name before the V is going to be the person unhappy with the case below, petitioning the court to hear this case. And then the respondent is the person who has to respond to that. They would rather this case not be in the Supreme Court because they were successful at the court below. And that's the name after that. In this case, it's the United States. Okay, I'm going to, at this point, turn it over to Gregg to give you some background. So even before we start to look at the specific facts about this case, we need to know a little bit about the background of the issue of presidential immunity and the other surrounding principles that are important.
Okay, so following along on the slide, starting with the notion of the rule of law, which is both the name of my organization and a key point here in this case. And it's actually, I think, a surprisingly difficult thing for people to define. People use that phrase without thinking much about it. So I really appreciate this definition here, which I think is quite good, that the rule of law is a bundle of concepts, including the notion that no one is above the law, that the law is something that is publicly and widely known, easy to understand, applies to all, equally enforced, not enforced selectively or politically, and that there is an independent system of resolving disputes here, our judiciary. So that's the notion of the rule of law. Separation of powers, another fundamental issue in this case, and that's how our Constitution is set up with three distinct branches: the legislature, which makes the law; the executive, the president, that enforces the law; and the judicial branch that resolves disputes which arise under the law. They all have different functions, and they are meant to be supreme in their lane. They're equal powers, but they're equal in separate categories. They interact with each other in delineated circumstances in the Constitution that we kind of loosely think about as checks and balances upon each other. The third note here brings us to this. It's an entrance point, I guess, to this concept of presidential immunity. Starting with the rule of law, no one is above the law. The second is this notion of separation of powers, that one branch can't unduly interfere with the operations of the other branch within its lane. So if there were prosecution of a president, it raises the question of the rule of law. What does he have to answer for under the law, or she have to answer for under the law? And two, whether the judicial system and laws written by Congress being applied to that person would infringe on in their sphere of responsibilities and violate separation of powers. So the Department of Justice has long had this notion that the Constitution would not allow for the criminal prosecution of a sitting president. It's not a judgment of the Supreme Court. It's practice of the Justice Department, and of course, ultimately, the president is the boss of the Justice Department. I don't know if there's any case law on this, but it's also generally understood that states can't criminally prosecute a sitting president. I think we can go to the next slide. There are kind of a bundle of ideas around protecting, insulating the president from legal challenges or scrutiny that might be burdensome to her ability to do her job. They are strongest around the idea of official acts, really core presidential powers. This is not very clearly defined, and we might disagree on what constitutes an official act or a core presidential power, which is probably a smaller set of official acts. But we look in particular to the duties that are particularly outlined in the Constitution in Article 2, which sets out what the president is responsible for. It's actually not terribly long list. George Washington, in his personal edition of the Constitution, he circled it and wrote down responsibilities, powers. So it's quite manageable.
Great. And then Kim is going to talk us through some of the precedents. And if you are following along in the case summary, you'll see that there are much longer entries for these. So just for time's sake, she's going to sort of give us the most important parts that we can take away from the precedents as they apply to this case.
Thank you. So just as a foundational concept, what's immunity? Immunity basically means, you can get away with something with no legal consequences. That's what immunity is. There is no immunity in the actual Constitution for presidents. There is immunity for legislatures, for members of Congress, and under the Speech and Debate Clause. So this question of immunity for presidents has had to be written into the Constitution or interpreted into the Constitution based on broader principles. And the first time this came up was in 1982 in a case called Nixon versus Fitzgerald. And just to make clear, another basic distinction in law is between civil cases and criminal cases. So as I tell my students, my law students, a civil case is one where you can get money damages. You can get that kind of relief. You can get money, or you can get what's called an injunction. That is an order from a court telling you to do something or not do something. And you can have private parties sue each other. A criminal case, the big difference is the only person who can sue or entity that can sue is the government, prosecutors, and the government can get money, but the biggie is the government can put you in jail, or in certain, under federal law, can execute you, and in certain states can execute you. So it's really has a bigger implication than civil law. The first time immunity came up was in a civil case where basically a disgruntled federal employee tried to sue Nixon over an employment decision that was executed by somebody lower within the ranks of the executive branch. And the Supreme Court said, listen, you can't have disgruntled employees suing presidents of the United States for money damages or for injunctions. That wouldn't work. It would be dysfunctional, and it would be endless. So the case created what's called civil immunity for presidents, that presidents know when they go and do presidential things, they're not going to get a bunch of people suing them civilly as if they were a private employer or a private, corporation, so to speak. The second big case was in Clinton versus Jones, which the question in that case, because we had Nixon was the precedent, Clinton versus Jones involved a civil lawsuit for sexual harassment that was filed based on actions that Bill Clinton took when he was Arkansas governor. He wasn't president. So the question was, if it's based on pre-presidential conduct, does that immunity apply? And the court basically said no and allowed that Paula Jones lawsuit to go forward. So in a way, there's a bit of an inconsistency in my view between these, because Clinton versus Jones did keep President Clinton, took him off task, right? It actually ultimately produced his impeachment because he lied in a deposition relating to that civil case. But the court did draw that distinction between pre-presidential private acts, you can be sued even if you're a sitting president, and official acts, you can't be sued. You can't be, citizens and employees and others running around trying to get money from the president because they don't like the kinds of decisions the president's making as president.
Great. Okay, so I'm just going to quickly put out the facts of this case. I assume we're all pretty familiar with them since we just lived through it and it was in the media. But it is important to make sure that your students are seeing facts, the facts, and they're all working from the same facts, because we know that maybe depending on where they're getting their facts, it might be different. So these are the bare basics. So in August of 2023, President Donald Trump was indicted on 4 criminal counts. And this was about the January 6th, 2021 activities. And you can see the counts there. Count 1 was conspiring to defraud the United States. Counts 2 and 3 dealt with corruptly obstructing the certification of the presidential election results, and count 4 was conspiring to violate one or more persons' constitutional right to vote.
Can I just
So-
add something there?
Yes,
People probably know
absolutely.
yesterday there's a
Oh.
superseding indictment, and the counts are the same. Just so people know, we have a new indictment in that case. They kind of move the facts around a little bit, but it's still the same 4 counts.
Same 4 counts. Great, thank you. And so Trump moved to dismiss the indictment based on presidential immunity. It went to DC court, which ruled that a former president enjoys no immunity from criminal prosecution. It was then appealed to the U.S. Court of Appeals for the DC Circuit, and it had the same decision that there was no immunity for criminal prosecution. So Trump sought Supreme Court review, and the Supreme Court took the case, which is what gets us to the issue in this case. Gregg, I think you were going to talk about the issue. Oh, no, sorry. I'm sorry. That was totally me. So the issue in this case is, does a former president enjoy presidential immunity from criminal prosecution for conduct alleged to involve official acts during their tenure in office, and if so, to what extent? So a few important things there. Kim talked a lot about the civil, the precedents that dealt with civil liability, but this is criminal prosecution, so that's going to be important. And the other thing maybe to think about, and maybe one of our experts can talk about this, is when a case goes to the Supreme Court, it's because the petitioner is the one asking the court to hear the decision, they get to frame the question, right? So maybe if one of you wants to weigh in on how you, even if you didn't know that, you might know from the way that this question is framed, that this was the petitioner's framing of this. Kim, you're nodding. Do you want to?
Yeah, I'm nodding just because, as I mentioned earlier, before this case, there is no such thing as criminal immunity for presidents in any source of express law, right? So essentially, you could have reframed this: does a former president enjoy any immunity from criminal prosecution? I think by framing it, this is that lawyerly thing, and it's well framed. Conduct alleged to involve official acts. It's kind of a nod to creating immunity based on what we just talked about. You know, the Nixon case, where the court did make a distinction between Nixon and Clinton, between private acts and official acts. So this is already kind of moving the needle towards almost an assumption that there's presidential immunity for some kinds of crimes, and saying, like, this is the bucket of the kinds of crimes using official power that should be immune. And just to be clear, I mean, immunity means there's an assumption that a crime was committed. That's part of, if there was no crime, there would be no need for immunity. Or at least prosecution or investigation. So that's, I think for some people, the idea of adding immunity itself was the threshold question that I think was almost, the court went much further than that.
Okay, so we're going to jump into the arguments, and Gregg Nunziata is going to voice the arguments for Trump, and Kim Wehle is going to voice the arguments for the U.S. These are not necessarily their personal views, and so they're just going to give voice to them a little later when we get to the Q&A. We can hear some of their own personal views, but at this point, they're gonna just talk about the arguments that were actually made by the parties. And I'll mention that if you're looking at the case summary where we took these arguments from, that we write those case summaries from the arguments made by the parties. So it's not our idea of what each side should have argued, and we try to include not all, because we need to pare it down for a high school classroom, but the arguments that they're making, devoting a lot of time to, making the biggest points about. So that's where these arguments come from. They're coming from the parties, and then we're trying to just rephrase them in a way that high schoolers would understand. And when we write these case summaries, we always send them through legal experts to make sure that in doing that, in taking these arguments down to hopefully about a 10th grade level, that we haven't lost their legal accuracy. So I'll let Gregg give voice to the arguments for Trump. He's not going to be able to talk about every single argument. So I've asked the experts to sort of highlight the ones that they think are most important, or the ones that ended up being most relevant to the decision. So you might not hear every argument that is on the slide voiced, but these are arguments that you will find in the case summary.
Thank you. Yeah, I'll try to be quick, and we can come back to aspects of this that people might find interesting later. But the core of the Trump argument is that a vigorous and independent president is essential to the operation of our Constitution. The Constitution was created, as you all know, to replace the Articles of Confederation, where we had no executive and we had no resolve in the seat of government. And the founders wanted a president who could act with dispatch, deliberately, to execute the laws, to respond to threats without having to run to consult with councils regularly, or to worry about being second guessed. And that notion lies at the heart of the balance of powers. The Trump position is that the court has recognized this in the past. We talked about Nixon versus Fitzgerald as part of this kind of idea of immunity, that we cannot let litigation burden presidential decision making, because if we did, we would be cutting the heart out of the Constitution, cutting the presidency that the founders gave us out of the Constitution. If the president cannot be subject to civil lawsuits, well, then certainly he shouldn't be subject to criminal prosecution. The consequences are so much weightier than having to pay a judgment. And if the president has to worry about going to jail after he serves his term in office, he will be chilled from doing things he needs to do to conduct his or her job. And that is a great threat to our system of powers, our system of separation of powers. They also mentioned a couple of things that I just want to flag here, really for later. Trump's lawyers argue that the main check on the presidency misbehaving is impeachment, which is spelled out in the Constitution. And the impeachment clause mentions that an impeachment will not foreclose a future prosecution, which they argued implies that impeachment must come first, and that a prosecution would be a follow-up action to a successfully impeached and convicted by the Senate president. And they also said that there should be such a strong presumption that the president is not subject to criminal prosecution, that any criminal law of general applicability, we talked about the rule of law in the past, shouldn't be construed to apply to the president. If Congress wants to make a president subject to prosecution, it would have to specify that specifically in each criminal law passed.
So the government's position, as I think I've laid some of it out, is that there is no presidential criminal immunity in the Constitution. And if you're a textualist, that is about reading the plain language and sticking to the plain language of the Constitution. Judges shouldn't be expanding it. If you want to expand the Constitution to expand the president's powers for criminal immunity, there needs to be an actual amendment to the official amendment of the Constitution. Gregg talked earlier about the rule of law, the idea of, an unlimited monarchy, like to use visuals. Unlimited monarchy is like a triangle like this. The king's at the top, and the power comes from God and trickles down. And this wasn't made in the briefs necessarily, but this is the theory. Trickles down to the people. Democracy is the other way, right? So the people are at the top, and it trickles down to those in power. And if you're going to say presidents can commit crimes with no accountability, that's putting us back into a kind of monarchy, which clearly was rejected by the framers. They were, there was a war fought to throw out King George III, and the framers were very concerned about the concentration of power in any one place. And so the idea of somehow putting him above the law is just antithetical to the structure of the Constitution itself. It also violates separation of powers principles in this way. That is, that each branch has its own job. Congress passes criminal laws, and the judges adjudicate trials and alleged offenses under the criminal laws. And by basically taking the president above the law, he is opting out of any accountability from those two branches. He's not bound by statutes that everybody else is bound by, and he doesn't have to defend his criminal activity in court. On the civil versus criminal law question, the point is that there is a big difference between civil and criminal laws, and if you're talking about an accountable government, you really don't want presidents committing crimes. So there's more of a need for accountability, not less of a need for accountability because it's a criminal case. The impeachment clause, I think Justice Sotomayor might have made this argument in her dissent. The impeachment clause actually makes clear that notwithstanding impeachments, that people who are impeached can still be criminally prosecuted and convicted. So to give the president criminal immunity would be to just write that part out of the Constitution, because the framers acknowledged that a post-impeachment you can be criminally prosecuted and you can be impeached for official acts, right? So it doesn't make a lot of sense to say to say that you can be prosecuted, but you actually can't be prosecuted. And the last point, I think the court didn't deal with at all. We'll get to that, which is, well, if there's anything there should be accountability for, it's January 6th, because that is really, the argument is anyway that it's overruling the peaceful transfer of power. And so it strikes at the heart of democracy. So if there's any kinds of crimes and actions that should be subject to some form of judicial review, civil or criminal, it should be the actions taken around January 6th.
Great. So we're going to take a little teaching tip moment here to talk about if you can't have Gregg and Kim Zoom into your classroom, how might you teach about this? Since, you didn't go to law school likely, and you may not have time to be as versed in this case as the two of them are. And I'm going to talk about an activity that we like to use, a pretty quick activity called classifying arguments. And for this activity, you take the facts, issue, and then unmarked arguments for each side and give them to your students and let them try to figure out which of these arguments might be for Trump and which of these arguments might be for the US. This is a way to take the temperature down in a classroom in some of these really contentious cases. I saw an article today, earlier today, that talked about teachers being needed to be brave and courageous. And I agree with that, but also I live by the saying, discretion is the better part of valor. I think it's a Shakespeare quote. And so, you can do those brave things in your classroom, but to have structured activities that maybe help bring the temperature down would be helpful. So in this activity, you can approach it one of two ways. We have a handout for it. Again, it's in those linked materials, and you can find it by going to store.streetlaw and just searching for Trump v. US. In this handout version, you just have these instructions where the students are going to read each argument and put a T on the line if they think it's an argument for Trump, and a US on the line if they think it's for US. So they're reading the arguments that Gregg and Kim just went over, but in random order. And it just helps them be able to think about which side would this support, and in the process, they're reading all of the arguments and thinking deeply about each of the arguments. Another way to do this activity, which I really prefer, and you can see some teachers doing it here, is to take the arguments and enlarge them a little bit and make them strips and cut them out. And then in groups, the students say these arguments are for Trump, these arguments are for the United States. The beauty is they're not saying they're not having to say in a classroom setting, I agree with this or I disagree with this. They're not having to debate. They're just recognizing them as arguments. And if for the groups that finish early, or if you want to give them a little more time, they can put them in order from what they think are the most compelling arguments at the top to the least compelling arguments. And that helps them to think about, these are the things I think are most persuasive. They can also look at most of these arguments have a point sort of counterpoint, like you heard Gregg and Kim talk about separation of powers. You both heard them talk about the founders and their views. You can also have students look at it in that way. And if you did want to have them take it to the next step and write an opinion based on who they think should win, they'd already have those points sorted out and in order that they think are most compelling. Okay, so that was my little teaching tip moment. Now we're going to dive back into the case, and we're going to talk about the decision. So also likely you know this, but we'll say it just so we're all on the same page. This was a 6-3 decision, very much along ideological lines in favor of former President Trump. The majority was written by Chief Justice Roberts. This case was handed down, it's not on the screen, but was handed down on the very last day of the term, which was July 1st. So they left it to the very end. Generally, the court doesn't go into July, but they did this year. He was joined by the other, what are usually considered conservative justices, at least in part. Justice Thomas wrote a concurring opinion, and Justice Barrett joined the majority, but also filed an opinion concurring in part, which Gregg will explain in a moment. And then what are usually considered the liberal justices dissented. Justice Sotomayor wrote a dissenting opinion. She was joined by Justices Kagan and Jackson, but Justice Jackson also filed a separate dissenting opinion. And along the way, experts, if you want to throw in why maybe a justice concurs in part, but then also feels compelled to write a separate concurrent or signs the dissent, but also feels compelled to file a separate dissent, people would probably find that interesting as well. So once again, not necessarily their personal opinions, but Gregg is going to voice the majority opinion and the concurring opinions, and then Kim's going to voice the dissenting opinion.
Okay, I may sprinkle in a little bit of personal opinion, but I'll try not to do too much. Majority opinion from the Chief Justice: the president is not above the law, period. But Congress may not criminalize the president's conduct in carrying out the responsibilities of the executive branch under the Constitution. And the system of separated powers designed by the framers has always demanded an energetic, independent executive. The president, therefore, may not be prosecuted for exercising his core constitutional powers, and he is entitled, at a minimum, to a presumptive immunity from prosecution for all his official acts. That is from the Roberts majority opinion. What you could maybe deduce from that, this breaks it down. It's worth saying Trump won, but he didn't get everything asked for. This is not absolute presidential immunity. The court has given us a 3-bucket structure to evaluate prosecutions against presidents. The first is absolute immunity only for acts that relate to core constitutional powers. So we talked a little bit before about that, what that universe might be, certainly open to some dispute, and will be no doubt litigated in the future, what counts as a core power. But a core power, immunity. Second bucket is non-core but still official presidential work. So it's not one of those really enumerated things like perhaps the pardon power or treaty powers that are in the Constitution. But other parts of the official work of president should enjoy some sort of presumptive immunity that will then courts will evaluate competing claims of whether or not the prosecution is necessary and how burdensome it would be if it went forward. And then the third bucket is unofficial acts, which enjoy zero immunity under this framework. So those are the three buckets, and that's what lower courts will be asked to apply in the future. I'll also just want to mention other things Trump's lawyers didn't get here was that argument about impeachment, that prosecutions can only follow impeachments. The court didn't take that up, or the idea that Congress has to specify a president whenever it passes a criminal law if they want him or her to be subject to that criminal law. So that's the majority opinion. Certainly a good result for Trump, but not everything he asked for. The concurring opinions, I think, are both interesting and very different. We have Justice Thomas and Justice Barrett both joined all or most of the majority opinion, but wrote separately. Thomas wrote separately to say that essentially this whole case should be thrown out because the special counsel wasn't properly established under existing law and the Constitution. It's a provocative argument that is not universally held, but some find it persuasive, and it's got some echoes in other cases going on now. But so he would have essentially thrown out the case even before getting to these questions. Justice Barrett joined the majority opinion, but did two interesting things. The first one that has drawn the most attention, and it is important, she did not join part of the majority opinion, one of the most controversial parts of the majority opinion, that says not only can you not prosecute that would not only discuss immunity, but it said prosecutors can't use evidence pertaining to official acts to prosecute non-official acts. And Barrett objected to this. She said it's absurd. If a president took a bribe to grant a pardon, the pardon's an official act, but that bribe is a corrupt one that's not official. And to say that prosecutors can't even look into the process of how that pardon got granted because it comes too close to official powers would be a recipe for disaster. So she doesn't agree with that. The other thing she does, which I won't go deeply into, but she says that she agrees with the rest of the opinion, but she would have approached it entirely differently. And she frames it differently, not as immunity, but as a limit on congressional power. And I think her opinion suggests, I think, a much more modest approach to immunity that would be grant more leeway for prosecutors to prosecute criminal presidents. And though she says her own logic is consistent with the majority opinion, I think that is a stretch. And the reason I like to highlight it here, because I think between that and Thomas, it gives you a little window into kind of the politics of the court. We never know, usually for decades, how opinions get arrived at. But I think Thomas and Barrett are so far apart from that opinion that they both join. It gives you the impression that maybe Chief Justice Roberts really had to work to come up with an opinion that could keep everybody under an umbrella because he wanted a majority, preferably a strong majority, on a case of this importance. It'll be interesting in seeing if these cases come back to the court, if those six stay together, or if in more narrow questions they start to splinter. And maybe you can imagine Barrett and Roberts and Kavanaugh having a more moderate view on these questions than maybe Thomas and Alito, but we shall see.
Okay, so Justice Sotomayor's dissent argued, as we sort of laid out when laying out the government's arguments, that there's nothing in the text of the Constitution that suggests that the framers intended to give the president even partial immunity. They knew how to create immunity. When they wanted to create immunity, they did it for members of Congress. And so if they wanted to do it for the president, they would have done the same thing, and they didn't. So that silence speaks volumes. And I think somewhat it will probably become even more well-worn. She said in the end, with fear for our democracy, I dissent, did not include the word respectfully. And I've actually spoken with one of her clerks and said, her former clerks, and said, she did that. She does that from time to time, but it's with a heavy heart. It's not a flippant thing to not include the words respectfully. Justice Jackson. So Justice Sotomayor's decision was really about the concern of concentrated power in the president, that If a president can, use official power, the military, to assassinate political rivals, then you don't no longer have a democracy. You've got something like a dictatorship, right? If you can't, as Gregg says, even use that evidence, you can't look into motive. You're just hoping that you've got just really ethical people that get elected because there's no meaningful check and balance. Jackson her argument was more about the court, and the courts, from her position, declared for the first time in history the most powerful official in the United States can, under circumstances yet to be fully determined, become a law unto himself. But the broader opinion sort of said the court shouldn't be the body that is doing this kind of thing. And also, and I can't remember if this is directly in, but I think this is another critique, that by leaving the majority left itself with the authority now to decide what's official and unofficial. So there's actually an expansion of the executive branch, but it's also expansion of the Supreme Court, because they're now the ultimate determiners of what the Constitution means, not the people through a ratification process of an amendment.
Great. Before my next quick teaching tip, I want to mention that the Q&A is open and we have some questions there. So feel free to drop your questions there. The next teaching activity, this is a really quick one too. If you maybe don't have a ton of time in class, students can read everything through the arguments. So they would also read the arguments, and then they would look at 2 unmarked opinions. This is what the handout looks like. It has the beginning of the case summary up through the arguments, and then it has this handout. Here are the instructions. They basically read everything. And then you can tweak these instructions. Here it says they should read the 2 opinions and decide which one they agree with and say that's the majority, and disagree with and say dissent. But if you have your students, maybe studying the makeup of the court, maybe you ask them instead to say, which one do you think the court found, this particular Roberts court found as the majority? You could do it, tweak it in different ways. So up close, this is what it looks like. If you are playing along at home and looking at the case summary, you'll see these are sort of just shorter versions of our summaries of the opinions, and with any kind of words taken out that's going to tip the answer, like the dissenters wrote or the majority wrote. And then you would have your students identify opinion A as the dissent and opinion B as the majority. It's a pretty quick activity. It especially is good if what you want to get at, maybe in a AP required case or something, is that students really understand what the majority opinion was. Okay, the impact. I'm going to talk about the short-term impact very briefly. We're going to have each of our experts weigh in a little bit on what they see as the long-term impact, and then we're going to open the Q&A. Kim and Gregg said they would be willing to stay around for about 15 minutes to answer questions. So if you're welcome to leave at 8 if you have to, but we're going to leave the Q&A open for a little bit longer if needed. Okay, the short-term impact. The very most important thing or the most immediate thing that happened is that the case was remanded or returned to the lower court for the judge there really to decide which of former President Trump's acts were those core acts, so have full immunity, which were official acts, so have that presumptive immunity, and which ones were private acts, so don't enjoy immunity. And that will happen in the not too long future. But maybe something that's important that when I sort of laid that foreshadowing of sometimes concurrences can be really important, is that one of the other cases that was going on, which was about the classified documents case in Florida, the judge there, District Judge Cannon, really used Justice Thomas's concurrence as a playbook for how to dismiss that case. She said she dismissed the case based on the fact that the appointment of special counsel was illegal. So that was maybe a short-term impact. And then yesterday, I had to change this slide this morning, updating to the last minute. Yesterday, as Kim mentioned early, a superseding indictment filed by Special Counsel Jack Smith was returned and by the U.S. District Court for the District of Columbia. So with the same 4 counts. And the key differences, just so you know, is it took out in the majority opinion, one of the examples that the Chief Justice used of things that were clearly enjoyed full immunity was anything that the Trump did with the Department of Justice. And so any reference to the Department of Justice is out of this new superseding indictment. So 5 pages kind of sort of just cut. Vice President Pence, when he's mentioned as specifically his role as the president of the Senate to maybe distance himself as his role of vice president. And that might be important. I'll let Kim and Gregg weigh in. And then all of the co-conspirators now are private citizens. In the original indictment, one of the co-conspirators was a DOJ employee. Okay, so Gregg, why don't we have you go first? What do you think the long-term impacts of this case may be?
Well, I mean, the best kind of lawyer answer is it depends, and it does. I guess I'll give you. There's a lot we don't know yet. I'll tell you a little bit about my personal views. Is that I was very disagreed pretty strongly with this opinion. I signed the brief that was in this case opposing and finding of immunity. So I'm not a fan, but I'm not. There are reasons to be hopeful, I think, for those of us who care about the rule of law. I mean, one thing is hopefully there aren't many more cases like this. It's been a long time that we've existed as a country now without having to debate how to handle prosecutions of former presidents. So just hopefully this doesn't come up again after these matters are settled with Trump. But if it does, this is a framework, and we'll have to see how it evolves. I think one of the most I think for me, if you think about this framework as a threshold matter, it doesn't sound that bad. There's a core of presidential acts that can't be criminalized. If you just sort of think about this hypothetically, we wouldn't want Congress outlawing, purporting to outlaw the president's ability to veto a law or to carry out his job in sort of kind of core ways like that. That seems sensible, and it seems sensible that you should be able to prosecute a president for non-official acts. What's most worrisome about the decision to me is that second bucket, where they grant this presumptive immunity. The language suggests that presumption is pretty strong, and it also suggests that the court understands official acts pretty broadly. We'll see if that stands the test of time. And I hope that as courts consider cases like this, the cases in the Trump matter and any cases that might come in the future, that as that bucket gets developed, it doesn't evolve in a direction that is as all-encompassing or as worrisome as it is to me. But that's where I stand now. I mean, there's certainly, if you want to be concerned, it can be a dangerous signal to people in the executive branch. I think we have reason to believe from history that presidents and their advisors in the past have worried about potential criminal liability for things they were doing, and it was a meaningful check on them. So it's concerning that that's gone. And then, just like my last thought, I'm sorry for going on so long on this, is this case underscored for me kind of the failure of our politics. I think the president is subject to prosecution for criminal acts, but I also think that our system kind of presumes that our political process will take care of the bulk of this kind of thing, that the impeachment clause should work, that people who criminally abuse their powers should be shunned from polite society and not able to win future elections. So I hope there's some sort of wake-up call here that the courts alone and the criminal justice system alone cannot be the ultimate safeguard of liberty, that it requires kind of a citizenry, an electorate that really cares about the rule of law and cares about presidents and all people in public life being proper stewards of the charges they hold. So sorry for not being terribly concise or focused on that one.
Well, I just want to say the questions in the chat are outstanding in the Q&A. There's so many that I want to get
Yeah,
to.
feel free to take a question if you
Yeah, I
want
mean,
to.
there was
I think
one
Greg
question.
just answered one of the questions about talking a little bit more about presumption of immunity. So
Yeah, I mean, I share Greg's concern. I would go further. I mean, I really, I think there needs to be I think law is about incentives, not about what the law says. It's about incentives and disincentives. If there's a speed limit, you'll go 10 miles over it until you get the ticket in the mail from the dreaded, camera hiding, and then you slow down. And the framers understood that. This is why they took a monarchy and broke it into three parts, because they didn't trust, to quote Madison, if men were angels, we wouldn't need a government, right? They didn't trust that people will just do the right thing. And I agree with Greg. In my new book, John Dean, who was White House counsel under Nixon, he went to prison around Watergate. He did the foreword to my new book, and he said, that criminal liability did have an impact. And that under this opinion, everything Nixon did would be official, and we would not have had Watergate. We would not have had him resign. So there are moments in history that the threat of criminal indictment, at least from one person who was in the heart of it and paid a price for it, he thinks that it can make a difference in terms of incentives. And if Madison's right, and I think human nature tells we need some consequences. So I think I'm very concerned. I think that I would say an amendment, people say it's politically impossible to put the Constitution back where it was in May. I think the court effectively amended it. And there was a question in here, is it really the more progressive people that are using originalism and textualism? I think in this case, absolutely. An originalist in this case. And then, of course, it looks intellectually dishonest because they reverse Roe versus Wade, because abortion is not expressed in the Constitution. So my view is you just need to have a common thread of what your jurisprudential philosophy is. If you're a textualist, you're a textualist. But you can't pick and choose textualism. Then you look like you're political, and that's a problem because these folks are not politically accountable. So a couple important things. Pamela asked, is there any resources dedicated to middle school? I mean, I did write a book called How to Read the Constitution and Why. It might be a little, if they're precocious middle schoolers, but it explains everything. And there's also on the HarperCollins website, there's teaching materials and study guides and things like that. I think it's the only place I know of that really explains the why behind these things in an accessible way. I have 4 kids, and 3 of them have gone through high school, and it's a lot of memorization. And Kathy, is obviously an excellent teacher and knows that when you're using materials that are provided to you, sometimes you have to get creative to get the students to understand that. There's another question here that is around concerns. It's actually also Pamela, about politics or bias. This comes up even in law schools, and my colleagues that just don't want to touch this with a 10-foot pole. I mean, my view is that, my second book is How to Think About Voting, or what you need to know about voting and why. It all comes down to the ballot box ultimately. I mean, that's the 2 political branches. That's how they're accountable. Of course, if a president is in his second term or her second term, or decides not to run for office, there won't be any accountability. But our kids who can't vote can't vote. So if they're underage, they can't vote. So to bury our heads in the sand and say this is too hard to talk about, they can't do anything about it. We've got to be the people to hold democracy for them. And so I do a lot of talks like on C-SPAN. I get callers in, and I really do think 2 things. Number one is if you give people the tools to understand how it all works, they can make the decisions themselves. And I think Kathy's materials are asking the students to do that. And I also just think, I have found you don't get into the political hotbed if you just don't let it escalate, and you go back to, okay, these are the tools. How do we use the tools? And you don't get reactive and get into politics. And also sometimes people just get mad at you, and that's just part of what happens. People get mad at me. I don't think Youngstown Sheet and Tube came up in the Trump
can you read the
case.
question, because they can't
Oh, I'm
see? I
sorry.
don't
Yeah,
think
sorry. I
they can.
apologize that.
I'm not sure if the participants can see the
Okay.
questions. That's all.
So there's a question on Youngstown Sheet and Tube, which is more to get into in this case, in this particular, but for that particular person, that Supreme Court case didn't figure prominently in this opinion. That's a kind of another webinar. I do want to make one point about, okay, what's next? And that has to do with the superseding indictment. And there are questions about the superseding indictment. So there was another case that went to the United States Supreme Court, or excuse me, the DC Circuit on immunity. There were two cases. There was that criminal case that went up to the Supreme Court and produced this. And then there was a case, a civil case called Blessing Game, where members of Congress and police officers on the street that were injured filed that civil lawsuit against Donald Trump, the one that would take from Nixon and take from Clinton versus Jones, and said we have immunity. And the court in that, the DC Circuit in that case said, well, there's a difference between if you're using the official, unofficial distinction, which has been the law in civil cases. If you are a candidate, and basically Trump said, well, I was president, so everything's official. I wasn't like Bill Clinton and Paula Jones. And the DC Circuit said, well, there's a difference between a candidate running for re-election and president. And the stuff he did around January 6th was as a candidate. And you can't, and he had his campaign staff, he had his private lawyers, he had his campaign lawyers. So what I think is kind of brilliant, frankly, Jack Smith reframed this indictment around candidacy, presidency, and reframed it all, this is candidacy. And so I think if the courts could make a clean distinction that would get us out of all this mess of going through all these tiers. And maybe it would prevent potentially another January 6th, while preserving, as Gregg indicates, this assumption up until now that you can't go around indicting presidents for doing their jobs. I think the majority was really worried about rogue prosecutors, but prosecutors have limits. Prosecutors have grand juries, prosecutors have judges, prosecutors have rules of procedure, prosecutors have appeals, and prosecutors also have public pressure. And all of that, I think, is less of a concern. But I think it'll be really interesting to watch whether this candidate versus president distinction carries the day. If so, I think that would be a good thing. And it sort of outmaneuvers the majority, frankly.
Okay, I wanted to make sure we got to this question, and then we're going to get back to the Q&A. This question was submitted in advance over email. Gregg, can you take this one? Other than the court overturning its own precedent, is there anything that can be done legislatively to blunt any negative impact their decision will have on the rule of law? And before he answers, I mentioned at the beginning, we kind of knew we were going to need more time for Q&A. If you have to leave, thank you so much for joining us, but we're going to stay on and take some Q&A for a while. So.
Yeah, I think, it's obviously there's the possibility of a constitutional amendment, as we talked about before. But in terms of narrower things, I think you can imagine Congress working to define what's an official act and defining throughout the U.S. Code what might be an official or non-official act of the president. Interesting that I mentioned one of the more controversial parts of the opinion is the limitation on using evidence of official acts to prosecute otherwise prosecutable crimes. I think the Roberts opinion says, well, prosecutors can't kind of poke around and dig up that evidence, but they could rely on the official record. So you could have more disclosure requirements from Congress. You could think about things that are subject to being abused as part of a criminal scheme, and require the president to disclose more of what he or she does in that realm, to have a public record upon which to frame an indictment at some point. I think, more broadly, there might be, and I think there is more energy now in Congress in thinking about limiting executive powers across the board, particularly presidential emergency powers that are rather open-ended, and cut Congress out and give him sort of a huge lanes to run in doing official acts that cause areas of concern. And there's kind of a bipartisan interest in doing something about emergency powers now. And finally, I think Congress ought to care about strengthening its oversight tools and its impeachment tools. And unfortunately, each party changes sides and how they feel about those powers based on who's in the White House. If a Republican's in the White House, Republicans are against powerful oversight and impeachment tools. And If the Democrats in the White House, Democrats are against that. But the institution of Congress needs to care about those powers. I think those powers are going to be, especially if criminal prosecution is more constrained, really important in ensuring accountability in the future.
One of the questions in the Q&A asks about the legislative branch might maybe jurisdiction stripping, or in other words, changing the jurisdiction of the courts in order to affect the court's ability to hear cases. So either of you have any ideas about whether that's a potential?
I mean, I've written about this. I think that so the Supreme Court, you mentioned the original jurisdiction. So you can file cases like against states in the Supreme Court. You can initiate a case. It's really rare. Of course, they don't want to be sitting around taking evidence and acting like trial judges. Everything else is appellate jurisdiction. It goes from a lower court and goes up. And the Article 3 specifically says that Congress can regulate and make exceptions to that jurisdiction. So in other countries, there's constitutional courts, or you could rotate federal judges in and out of the Supreme Court. It says there should be one Supreme Court, but it doesn't say they have to be special Supreme Court justices. It does say they have to have life tenure and salary protection, but you could use appeals court judges. I mean, there are lots of things Congress could do, or Congress could, be more specific about the kinds of constitutional cases that the court could get. I mean, Marbury versus Madison itself, where the court declared it has the right of judicial review. The court gave itself the right of judicial review in Marbury versus Madison. That's not in the Constitution. That would require, supermajorities in the Senate, because the filibuster would apply to routine legislation. So the problem is more political, but it's an excellent question and a very thoughtful question. The same thing with, as I said, the Youngstown sheet and tube, where essentially the court said that presidents can't start grabbing the powers of other branches. I think the argument is the president is sort of stepping over the power of other branches, but isn't trying to legislate or doing something that's the power of another branch. So it's a little bit different. There's one point I did want to. There was a great question about how did the majority get around the impeachment clause? And it was very circular. Chief Justice Roberts said, well, the impeachment clause doesn't make the distinction between official and unofficial acts. So it's not really an answer. It says, well, the impeachment, we're going to do what we want to do because the impeachment clause isn't specific enough. But it's a little bit illogical, because I think the effect of the decision, given, as Gregg indicates, it's so broad, this idea, it's such a strong presumption and it's so hard to overcome it, and the standards are so limited. In theory, if the court were to decide pretty much anything someone does once they're in office, unless it's, lying in a deposition in your divorce, is going to be an official act.
I wanted to ask a question about, because we got some variation of this question sent into us beforehand, and there's at least one in the Q&A about how the decision in Trump v. US might impact how we teach about US v. Nixon, or does it impact about US v. Nixon? So, one is about executive privilege, one is about presidential immunity, but obviously there's some overlap there. So I don't know who wants to take that question, but we've gotten that question at least 3 times.
Yeah,
so
I mean, I think, because you teach that case, I was actually thought about writing a law review article about this or something. I don't think it's something the court grappled with. And again, it's a really outstanding question. I wish you were all in my 1L classroom. It's such a good question. So the court in that case, you talk about official acts, that case was about Nixon's Oval Office tapes, the audio tapes. I mean, that's the heartbeat of the presidency. That is his confidential communications with world leaders, with his top advisors. Like, that is, if there's anything that's official, what he says in the Oval Office. And there was a prosecutor, was then called a special prosecutor, that subpoenaed, through a grand jury subpoena, those tapes. And a unanimous Supreme Court created this idea of executive privilege and said, the president gets a presumption of protections for that stuff, but it can be overcome if there's a stronger need in the criminal justice system. So to answer your question, I mean, it's hard. You're teaching younger people. I think they clash. I don't think they're necessarily reconcilable. The court gave lip service to it and said that's still good law, but didn't kind of, draw the line that's being drawn here by people that are watching this. I think immunity could gobble up executive privilege, particularly since the court said you can't use the evidence. And I'll just give you a little anecdote. I was in the green room at CNN after this, and there were former Trump lawyers that have represented Trump who said, hey, if we had this opinion, we just wouldn't have produced any evidence in connection with the January 6th congressional investigations. So I think another kind of sleeping giant about this case is, does it just mean we're not going to get information, period, out of the White House, and that it basically makes executive privilege irrelevant. I also did want to make one point about the Mar-a-Lago case. There's a question about the appeal of that and the constitutionality of special counsel Jack Smith. Nixon also, it wasn't the core holding, but there was a challenge to the special prosecutor's power, and the same statutes that are backing up Jack Smith, the court held those do give that special prosecutor, it was called a special prosecutor, but not a special counsel, gave that special prosecutor the same power. So I don't, Greg might be able to speak to Thomas's concurrence, but I think that's really kind of, canon swept aside that case, the dicta in that case. There was also a question about how does it impact the other cases, including Georgia. I think anytime the president did something as president, now it might be off the table. So packing up the boxes to go to Mar-a-Lago, he was president. He made decisions under the Presidential Records Act, which doesn't protect those, doesn't mean they're his documents, but it is an exercise of his decision-making authority under a statute. So maybe that's out of that case. I don't know how Smith's going to get around that. In Georgia, he made the call to Brad Raffensperger with all his, a number of his top advisors on the phone, right? He was president at the time. Even in the New York case, he signed some of the checks to pay back Michael Cohen from the Oval Office. One of the top witnesses in that case was Hope Hicks, one of his closest advisors. So this does throw a monkey wrench in all four of the cases.
Okay, Greg, what are the odds that the court will take another case to define official acts, or will it be resolved by the lower courts? Is the last part of that question.
Yeah, I mean, I think, well, a lot depends on who wins the next election, I suppose. And I think they're not in a hurry to revisit this. So I'm not expecting to see this at the court anytime soon. But I think I will say, I feel like it's worth saying that I think there's a tendency to be fully cynical about this, and that this is Republican justice protecting a Republican president, and I really don't think that's true. I mean, I think there was Kim was mentioning before that they were worried about rogue prosecutors and politicized prosecutors putting our system of separated and balanced powers out of whack. I think that's a misplaced worry for a lot of the reasons Kim mentioned, and I'm more worried about presidents abusing their powers. But I think it's consistent with sort of the legal thinking of a lot of these folks going back a long time. I think it's wrong, but I mean it's another question this raises, and maybe this is a little bit too complicated for high school, or maybe not. It's just how big decisions should be at the Supreme Court. I mean, I was of the view that this case could be resolved fairly easily by focusing on this is a very narrow thing about a president trying to illegally stay in power, which is almost definitionally unofficial by my lights. And of course, that doesn't come anywhere near a question of core powers that we're protecting. And I would have resolved it on those facts. And I think that would have been better for America. The justices, as Justice Gorsuch kind of said during the opinion, sort of famously, we need to write an opinion for the ages. And the court wanted to set up a framework that could be applied for generations. And that's not always the best idea. And this is kind of a big question in law is how much courts should do, how much appellate courts in particular should do, whether they should go small or go big. And there's in all sorts of cases, there are indications pointing in both directions and arguments about that. But I think this was a big mistake for the court to try to solve problems that might not even arise.
Kim, did you want to add something? I thought maybe.
No, I mean, I'm not nodding vigorously because I agree with everything he said.
Okay, great. Okay, so it is 8:13 and we have more questions, and it would be great to keep it going forever, but I probably need to let our experts get on with their evening, and all of the teachers too, because they have early mornings tomorrow. One commercial before we go is if you go to our store.streetlaw.org right now, there we have a sort of curated a bunch of our resources, some of which are middle school. I know Kim mentioned that before, some middle school resources about teaching about voting, the elections, and the presidency. They're all sort of in one place. Some of the things we have there are deliberations about, should the Electoral College be disbanded, and this case and all of the resources around it are there. There are things about gerrymandering, I mean, all sorts of things. So check that out if you're looking for all sorts of resources, not just case summaries, but lots of other variety of things too, to teach about the presidency. Also, we have a legal timeline on the powers of the president, and it will be updated soon to include Trump v. US. If you don't already get all of our updates and things, you probably do. That's probably how you found us. But if you don't, grab that QR code and you'll be in the know for everything that we do. If you heard stuff tonight and you want more details about anything, you have questions for me, I'm all over the website. I'm cbruffing@streetlaw.org. Please feel free to reach out to me if you need directions to resources or anything like that. And thank you so much for attending. I know it's really hard after a long day of teaching, especially to show up at a webinar, but we really appreciate your attendance. We hope you learned something about Trump v. US and maybe about some teaching resources. And of course, a very big thank you to Kim Wehle and Gregg Nunziata for taking time out to prepare for this and attend tonight's webinar. We really can't do what we do without our legal experts. Everybody buy Kim's book and show up for their for their talk on Kim's book, and support them both, because we thank them very much and appreciate everything that they do to help us. Greg also, just so you know, is super helpful at our Supreme Court Summer Institute for Teachers, and does a lot of reviewing of our materials so that we make sure that they are legally correct, including lots of things that we have done in the past about nomination and confirmations. So thank you all so much.
Thank you.
And there'll be a recording that will be sent to you later if you know somebody who you think might enjoy this but missed it. So thank you. Have a good night.
Thank you all. Thank you so much.
Bye-bye.